The judgment that you gave, that is not relevant. Appeal is dismissed.
Much. May I please? It's restricted to item number 12. I'm appearing for the income tax department. Last again, also directed me to publish the record, submit one report. But the one report we filed through affidavit. Should be allowed to file the second report through affidavit. So,
This is for the appeal.
Mr. Mauda,
I
know time.
Any objection?
No objection.
Mr. SCPL, Learned Counsel for the Income Tax, submits that you would like to file the second report
Second report through affidavit.
by way of an affidavit. Mr. Ash,
Mr. Ramesh Goenka.
Mr. R. Goenka appears for the petition. Prayer of the counsel for the respondent is allowed. This is the matter after vacation.
Much.
May I please, Your Lordship?
Yes.
As regard item number 2 to 6, my lord.
Yes.
Yesterday, my lord, adjournment application was circulated.
By you.
I am praying for adjournment, Your Lordship,
Why?
after vacation.
Why?
Today, my lord, some uttered matters are
Where? Utter matters where?
before court number 5.
Who is for the other side?
Other side, my lord,
Mr. B. Google.
Okay, right. The prayer for adjournment made by way of a written application not having been objected to by the counsel for the respondent. This is the matter after respondents. This is the matter after vacation.
deeply organized.
But I beg to mention for listing of a case note. Criminal IA criminal matter.
After vacation.
It's not only my lord, confirmation of delay of 7 days only, my lord.
Okay,
Yes, my lord. Monday, my lord.
okay.
Obliged.
Lordship, I just wanted to place for a listing of one criminal appeal, which is ongoing. The last, it was on 38th of July. It was direct.
Book has been made or not?
It was asked to make the book, but till now,
Next.
Monday.
Lordship, I beg to mention item number 10.
Yes.
Mr. R. Sharma is the amicus curiae, Lordship. He could not be present today due to certain personal difficulty.
Anyway, one of us cannot.
Yes, Lordship cannot take up.
Yeah, right, on the prayer for adjournment made by Mr. Rakesh Sharma. Correct?
R. Sharma.
Rakesh Sharma. Then the mic is curious. This is the matter after vacation.
Obliged.
Doesn't matter. Matter. Yes, Mr. Gogoi.
Yes.
Have you given a copy to them? So this is for,
That 42, that defense personnel not within the ambit of that 42.
they are not within the ambit.
Otherwise, Lordship, the list is there also. The central pool list, I have check mark one lordship. The next are one in respect of defense personnel guideline lordship. CL number one lordship. CL number one. That petition respondents will come lordship in priority number Roman 8 lordship. Then my lord may kindly come to next page's lordship. Next page in respect of the central pool seat allotted to the state of Nagaland lordship. Next two lordships, number two lordship.
Yes.
It is the seat allotted by the Ministry of Health and Family Welfare and various medical colleges of India lordship.
Ah,
Then lordship, next three lordship.
ah,
He is the lordship, the seat allotted to the defense personnel in the various medical colleges of India
okay.
lordship. And
So basically,
regarding that 42 seat is exclusively domain in the state lordship.
that is, so this, it is not for army personnel.
No, army pass
So this person cannot be given.
lordship. No, in respect to army person, there is a specific lordship to type police, their lordship.
Yes, that's my contention.
Correct. No,
Yes.
can you give a affidavit? Yes.
But yeah, it will take time. Other
It doesn't matter because it has to be clear.
lordship.
Let it be in writing clearly. actually.
Then lordship, it will take another 3 weeks.
No, Lordship, we are running against the
No, so no.
Will it be tomorrow, Lordship?
No, no.
So how can it be
Wait a minute,
possible?
how could it be tomorrow?
Oh.
The issue is, now there is a stay order or what?
There is a stay order, but your Lordship, the last date for taking admission is on 8th of October. So we are running against time. Because once this court interfere, then that seat will be given to the another
Whereas
candidate.
my lord may,
We stay if we stay the single bench or.
otherwise my lord may made a part of the record lordship, it's by the ministry lordship.
No, we wanted in clear cut, right,
Okay.
because they will go to Supreme Court.
Lordship.
Can we file it by, within a week?
Within a week lordship, it is difficult on my part, otherwise it's go to the Delhi ministry lordship. Even lordship, the secretary, concerned secretary is also lead lordship. He is in the outside of India.
Where is the counsel for the other side?
Today they are not appeared.
Today they are not here. You see, we cannot decide with the, what we can, then they have not been given this copy of.
Lordship, I have not received any email or lordship phone number, so mobile, mobile numbers also lordship.
Where are they? Anyway, we'll give them one chance. We'll list it on Monday. We'll list it on Monday. And if they don't come, then we'll decide them.
Okay, Lordship.
Enough.
In the meantime, we have the numbers. Respondents, sir.
Yes, but it is their duty also. They have been
No,
pursuing
no,
this matter.
I'm not saying that.
Yes,
Communicated.
Maybe purposefully they didn't appear.
This is not the issue, just I asked for communicate this.
I want to communicate.
I want to
Okay, okay.
communicate it.
I'll give you.
Okay.
the number.
Then it will be easier for them also. Lordship.
Right.
Monday.
Ms. V. Stokely. Acha, what is, you said that 8th October is the last date?
Yes, for taking the admission.
Taking it.
Yes, all India, everything 8 is the
They have
last
to
date,
lordship the
Lordship.
various medical.
So we are running
colleges,
against
seats are
the time.
allocated, Lordship. They have to, various medical colleges of India, almost lordship, 30 medical colleges of India lordship. They have just seat allotted state of Nagaland for central lordship lordship. So they have to lordship, they allot the seat to the concerned candidate within that period of time lordship.
So by Monday, if it's done, Monday we pass the order, we.
So lordship, if they deliver the phone number, I can lordship.
Give it with
Yes, I'll.
Ms. V. Stokely, Leonard A.D. appears for the FL. Mr. K. Gogoi, Leonard CGC appears for the Union Assembly. No one appears for the private respondent / writ petition. Next para. This court. Right, order dated 8/9/2020. Directed Mr. K. Gogoi, learned CGC. To obtain instruction with regard to whether clause 4 of the office memorandum dated 28/7/2025 would include army officers. The said issue was to be clarified by the central government, by the Union of India, as the said office memorandum had been issued by the Union of India,
Ministry of Health and Family Welfare.
our Ministry of Health and Family Welfare. Next one, Mr. K. Gogoi, the learned CTC submit that as per instructions received by him and in terms of the letter number C full stop 18018/01/2025 Roman 2 dated 17/9/2025 issued by the Under Secretary to the Government of India. It is addressed to the learned CDC, comma. The clause 4 of the OM dated 28/7/2025 is not applicable and does not include army officers. Comma, in as much as a separate quota has been reserved for army personnel
Yes,
under the central pool scheme.
yes.
Next paragraph. Though we were no, as the last date of, as we have been informed that the last date of admission to the MBBS course is 8/10/2025. During which time this court will be on vacation. So we were desirous of disposing of the matter today. However, as no one appears for the private respondent / this particular, we adjourn the matter till Monday. To enable the counsel for the private respondents / this particular to appear before on the second. This is the matter of.
I have no inspection with part of the record.
The letter dated 17/9/25 issued by the Under Secretary to the Government of India and no, that's all, no?
Yes, sir, yes, sir.
Is made a part of the reform
Yes.
and marked as an exchange. Today's what day? 18. 18/9/25.
Attachment.
So they're kindly relieved
Yes.
for them.
Attachment.
What to do?
Sip, may some submit something. Here the thing is that, yes, it should have been 22C, instead of 21C. But the thing is that,
No charge has been framed.
but I don't know whether Charge has been framed but wrongly framed.
Under 21C, it has not been framed.
Yes,
So,
not in 20, it should have been 22C. Charge was framed under 21C.
correct.
Yeah.
Yes, it had, yeah.
The only thing is that, my lord, they have to show, because under section 464 and 465 of earlier CRPC, now 5110 and 511 of this BNSS, my lord.
Yeah.
Let me kindly produce 511 BNSS. First, 510. 511. Did I read my?
Eleven is not applicable.
My lord, here 511 the below portion, my lord. Whether it has been raised earlier or occasion, my lord.
Huh? Huh?
Whether it has been raised, whether 511 subsection 2.
Yes.
In determining whether any error, omission, or irregularity.
No, before 500 to come to 511(1).
Yes,
Subject to the provisions contained here and above.
yes.
Here and before. No finding. Sentence or order passed by a court shall be reversed or altered by a court of appeal confirmation on account of any error, omission, or irregularity.
Irregular.
Error, omission, or in the complaint,
My lord, complaint.
summons, warrant, proclamation, order, judgment,
Yes.
or other proceeding before or so or during trial. No, how is this applicable?
My lord, here that irregularity has crept up in the judgment itself because 21C.
No, Mr. It's like this. It's
Yeah.
like this. Supposing charge is framed for kidnapping.
Yes.
Under 302. It cannot be,
Cannot.
but it has been framed under 302. And he has been convicted of kidnapping and sentenced under 302. Would that amount to giving sufficient notice to that accused to defend himself for kidnapping when the charge is made under 302 for kidnapping? How can it?
My lord, here then my lord 464, my lord, I mean 510.
500, 510, 511 is different.
Yes.
511 is no finding sentence or order shall be reversed on account of any error, omission, or irregularity in the complaint. Complaint is nowhere there.
Yes.
Summons is not there. Warrant is not there. Proclamation, order, or judgment. So there is no. It does not talk about non-making of the correct charge. 511 is not applicable.
My lord, in that case, my lord may peruse 510.
Yes.
510.
No
Okay.
finding, sentence, or order shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission, or irregularity in the charge, including any joinder, rejoinder, unless in the opinion of the court.
Yes.
Unless in the opinion of the Court of Appeal, a failure of justice has in fact been appealed. Prima facie, we find that a failure of justice has been occasioned. When you have not framed the charge under 21C, how will he make a defense under 21C when charge is not framed?
But in my humble submission, my lord.
No, it was the law.
Yes, my lord.
Not this,
Sir.
you're going to read this in the context of the law laid down.
Yes, my lord, I will place my lord. On my humble submission, my lord, both in, if it was framed in 22C, the punishment would have been same.
Maybe Mr. Asif 22C does not talk about heroin.
Doesn't talk about heroin, my lord. That is psychotropic substance. And 21C is basically heroin.
Correct.
Then, my lord, that error happened in the framing of charge. But they didn't took this plea earlier occasion. And there, because SARS was explained to them, 313 also, they have not talked about them, my lord. Yes, there was the irregularity, there was a failure, my lord, framing of charge, my lord. But suppose, my lord, it was framed in the wrong, my lord, 22 itself, my lord, 22C in a correct way. And it would have been proved in that way itself, my lord, and the punishment would have been the same, my lord, because the punishment prescribed under 21C and 22C is same. They have to show that, my lord, how they have been prejudiced. Because they participated in the trial, they have given all the opportunity of defending themselves, my lord. And in this regard, I would like to place one citation that I have already 1998 6 SCC. There are 9, 10, 11. May I repeat?
Yes,
There are 9, 10, 11. May I read?
yes.
Before considering the factual aspect of the case, it will be necessary to adhere to question of law relating to validity of trial raised by Mr. Arunachalam, the learned counsel appearing for so and so. He contended that the charges were not framed against the accused person in accordance with section 211 of Code of Criminal Procedure. In the charge framed under section 148 IPC, though it was alleged that they were the members of an unlawful assembly. It was not mentioned what its common object was. Besides, the contended a charge under section 302 IPC simpliciter was framed against all the accused persons, not with the aid of section 149 IPC, for which they were convicted by the trial court. He submitted that an accused is entitled to precisely know the exact nature of charge brought against him. According to him, unless he has this knowledge, he will be prejudiced in his defense. Particularly in a case as the present one, where he is sought to be prosecuted for acts not committed by himself, but by others with whom he is in company. It is undoubtedly true that charges are suffered from the infirmities pointed out by Mr. Arunachalam, but the question is whether the trial and for that matter the conviction recorded against the accused were vitiated thereby. Then subsection 1, section 464, the Code of Criminal Procedure 1973, which is now section 5110, madam, expressly provided that no finding, sentence or order, well, this I am skipping, this is I'm reading, madam. No finding, sentence or order by court of competent jurisdiction shall be deemed to invalid merely on the ground that no charge was framed or on the ground any error, omission or irregularity in charge, including any misjoinder of charge, unless in the opinion of the court, appeal, confirmation or revision, a failure of justice has in fact emphasis supplied been occasioned by thereby. Subsection 2 of the said section lays down the procedure that the Court of Appeal, confirmation or revision has to follow in cases it cases, it is of the opinion that a failure of justice has in fact been occasioned. The other section relevant for the purpose of is section 465, which is section 511 now, of the code. It lays down that no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, or irregularity in the proceedings, unless in the opinion of the court, a failure of justice has in fact been occasioned. It further provided inter alia that the determining whether any error, omission, or irregularity in a proceeding under this code has occasioned a failure of justice, the court shall have regard to the fact whether objection could or should have been raised at an earlier stage in the proceeding. Para 11, this court in William Stanley versus State of MP elaborately discussed the applicability of section 535, 537 of the Code of Criminal Procedure 1898, which correspond respectively to section 464, 465 of the code, and held that in judging question of prejudice as of guilt, court must act with a broad vision and look to the substance, not to technicalities. And their main concern should be to see whether the accused had a fair trial, whether he knew what he was being tried for, whether.
You see, the question is this, in that case,
Yes, right.
there were a number of persons,
My lord.
but charge had been framed only under 302.
Right.
It should have been framed under 302/149.
Yes.
Common object. So that was the difference.
Yes.
The main offense was 302. Only thing is for a common object to be achieved, that 149 was supposed to be there. So that was not there. Out here, it is not out here. The fact is that he should have been charged. The main case should be under 21, but he have made it 22. That's all.
And here I'm just.
See, out here, not a case that out here instead of 302,
My lord.
they have made it under 304. You know, or 304B or 304A or whatever. Now, so that is the difference. Out here, the thing is that it has not been, they have not been charged under section 21. That's all.
I mean, here only this next portion, I just wanted the law laid down.
Yes.
Lot to technicalities, and their main concern should be to see whether the accused had fair trial, whether he knew what he was being tried for, whether the main facts sought to be established against him were explained to him fairly and clearly, and whether he was given full and fair chance of to defend himself. Viewed in this context of the above observation of this court, we are unable to hold that accused person in any way prejudiced due to error or omission in the charges pointed out by Mr. Swenso. Apart from the fact this point was not agitated in the either of the courts below, from the fact that material prosecution witnesses.
Either of the courts below, they've come now the first time. Straight away.
My lord.
Then-
Then next portion, my lord, where cross-examined at length from all possible angles, and the suggestion that were put forward to the eyewitnesses were fully satisfied that the accused persons were not in any way prejudiced in their defense. While on this point, we may also mention that the examination under section 313 of the code, accused persons were specifically told of their having committed offences, besides other, under section so and so, so and so.
Ah,
For all these reasons.
correct. So they have mentioned it
Yes.
in their 313. The relevant provisions have been mentioned. Where in your case, where has it been mentioned?
My lord, my contention is that, my lord, yes, my lord, there is irregularity, my lord.
They
But-
differentiated.
Yes, my lord.
Out here, the accused persons were specifically told of their having committed offences under 148 and 302/149.
Yes, my lord. That has not been.
That is
explained
not
here.
here.
Not here.
Then. How does this, what is? Completely different. You see, there's so many judgments. There's so many judgments which say that unless they have been given a chance to defend themselves against the charge that has been framed. Then the entire trial is vitiated. Now, in this case that we have mentioned, they were given the chance to defend themselves against 302. Only thing they forgot to add was common object for 149. That's all. But the main case 149 was there. And they have also said accused person was specifically
Told, my lord.
of their having committed offense besides others under 148, 302/149. Here there's nothing. It's quiet.
Here, my only submission is that, my lord, they didn't raise this issue, my lord, earlier, and
How does it matter? They did not raise the issue. Why didn't you also raise the issue? It was your duty.
yes,
You have to prove the
Yes,
case.
yes,
It
yes.
is not they have to prove
Yes.
the case. The only thing we can do is we can send it back and let the proper charge be fixed.
my-
In that case, Lordship, my only prayer is that I may be allowed to go on bail. If
that I
the
have
matter is
objection, ma'am.
remanded back.
That
If
I-
the matter is remanded back, Lordship, at this point of time, due to irregularities,
I will be in jail.
3.7 years as of today.
my lord, this is a commercial quantity case, and
This is,
since
a-
my line
there
of
is,
time
an-
is.
there is an irregularity in the, in misinterpretation of law and irregular procedural lapses.
What
For which,
what misrepresentation?
of-
What misrepresentation?
being charged, being framed under a different
That
section.
is not a, that was a error.
Error.
That's
That
not
is
a,
a
that's not a
error.
misrepresentation.
I-
It's an
I-
error committed.
Error, Lordship, error. Due to that error, I may be allowed to go on bail because remanding me back would take more time. And for that, I may not be
You're supposed,
punished,
you're
kept behind the
if
bars.
you're convicted, you're supposed to be in jail for not less than what? 10 years,
More than 10.
not less than 10 years.
Yes. More than
Maybe
10.
Lordship, that has to be, that is a matter that is to be looked after during the IE hearing for suspension of sentence. I have not got that opportunity for that hearing yet. Before that, only the matter is being remanded back. I have this citation of this Honorable Supreme Court, which
How come?
Regarding bail, my lord, I have objection because if my learner can want to submit regarding bail, then I have a chance to give an objection, filing my objection, my lord. She didn't pay till
No,
like-
you have committed a mistake.
Yes, ma'am. But the fact remains, my lord, contraband was recovered. Yes, there is a mistake in the framing of charge, my lord. But that per se doesn't give him right to go on bail, man. It's a commercial quantity case, man. Either way, my lord. Had it been heroin or had it been.
this is a case,
particular substance, it
this
was
is a-
commercial.
What about judgments of the Supreme Court? So many judgments that if they have been in jail for 200 days,
My lord,
or
that is,
300 days,
that
and
is-
this also due to an error committed by you. You also perpetuated that error without bringing to the notice of the court that there's an error has been made.
my lord, here the question is whether that following incarceration come, my lord, in place of regular where trial is pending, my lord.
So
But here trial is over.
the trial is over and we're going to restart the trial.
My lord, and one thing is that my these persons are not from Assam, my lord. They are from Akkad state, my lord. The flight risk is also there.
that
That
is
for
one
that-
word on affidavit, Lordship. I will appear
No,
before this
that,
court.
that.
I have filed, that affidavit is there, my words are there, I will appear.
There is IA for bail.
Yes.
Then in case, my lord, since 10 years conviction is there, then I have a right to file a objection.
No, no right.
Lordship, this is.
You can go to Supreme Court if you run to 13th this court.
My lord, and in commercial quantity in 389 petition also, when granting bail, a person has to see whether, when this provision of 37, my lord.
What has the Supreme Court said with regard to 37 in so many cases?
My lord, may like to, I have one place, our coordinate based judgment here, already Supreme Court judgment has been discussed, my lord, so I didn't want to burden your lordship. IA criminal 573, 2019.
But the judgment that I have submitted, that is 2002 5 a latest one
Yes,
by the Honorable Supreme Court, which
2002?
2025 legal.
Yes,
action.
yes.
Yes, Kailash. Lordship, in this case, the Honorable High Court also remanded back the accused person for a retrial. And based on which the accused person preferred an appeal before the Honorable Supreme Court, and the Honorable Supreme Court was very much pleased to release the accused person on bail due to the matter, as the matter was being referred back to the learned trial court. Another, I have provided another 3 citations along with this. There are 3 more citations of the Honorable
You're
Supreme
not
Court.
hitting the nail on the head.
So whether those are commercial quantity cases, my lord.
Those are heinous of pen 376 is there.
There are enough judgments. I'll bring it up. You see, In 2023, SEC online, Supreme Court has held grant of bail on ground of undue delay in trial cannot be said to be fettered by section 37 NDPS. Okay, that is Muhammad Muslim Hussain was state. Then
Then Ravi Prakash is there, my lord.
B. Prakash,
Yeah, Ravi Prakash is
Orissa,
there.
23.
Very
Yes,
recent.
Found incarceration must override the statutory embargo state under section 37. Prolonged incarceration. There are a lot.
My lord,
2 years also.
there are a lot of judgment from our court also. But the
Correct.
thing is, my submission is these are all in my lord pending trial, death and facts are different, my lord. In my lord Muhammad Muslim, if I am not wrong, my lord, if 5 or 7 years out of 30 witnesses, only 7 witnesses were examined on that ground, my lord, this order was passed.
Anyway,
My lord,
we'll-
here I have submitted one judgment of our coordinate based judgment, my lord. Kindly produce space para 10, my lord.
Meitei. From Meitei and Jalaluddin. Obol, Manipur. Both from Manipur.
Yes.
May I read this judgment, my lord?
Why don't you apply before the trial court? One. Then you can come here. It's not allowed.
Lordship, already, I have not been released on bail since the whole period. 3.7 years I have been in custody. I was never allowed to go on bail.
Naturally,
And-
you are. What is the amount of
It's two-
amphetamines?
2.2 kgs.
2.2 kgs.
2.2.
Lordship, even if the matter is not remanded back, I may be given the chance for the IA hearing, because Lordship, there is irregularities that I can place before this honorable court, and the honorable court most likely would please
What is the irregularity?
mandatory compliance of section 50. Section 50, what it says that right as
What is seized from the body of
yes,
that?
personal body search. What it says that he has
What is it?
yes, he has to be given a right to be searched before a magistrate
Not
or a
followed.
yes, that is not followed.
Where do we?
So the main question of discrepancy arises the seized article in question. There is a question, there is a question mark that even if the seized article existed or not, because the seized article were never produced before the court.
Never produced.
Never produced. Not the
Sample.
Uh-huh.
Sample.
No, nothing produced.
Photographs.
Certificate under inventory in absence.
Say 52A under
In
52A.
absence of primary evidence that consists of the contraband, what constitute of a primary evidence is the section 52A inventory.
Correct, correct.
The section 52A inventory dated a year back. My case took place on 2022. Inventory dates back to 2021.
Where is that?
Uh,
But in that case, Bharat Ambali judgment is clear.
in that case,
Bharat Ambali judgment is clear.
What?
My lord, if photographs or certificates in place of my lord, original composition or produced, it's a.
No. The main thing is the inventory. Not
My lord, and
photographs.
in,
Photographs, I'll print out a photograph today, supposing I say this is taken 5 years back. How will you?
my lord, if your process is hearing created, then I may be given a chance to pay the objection.
We have heard you.
Lordship, inventory page
But you enough-
169 of.
Give you enough time to say to consider this issue. We have got the orders. Don't ask for time anymore, please. We're not giving you time, so don't ask for time. You want to give some submission that we will allow. Yes, tell me.
Lordship, inventory page 169 of the paper book.
169, yes.
Here, point 4, date of seizure 7/2/2021. 7/2/2021, whereas the incident took place.
Of Caesar.
The point 4. Whereas the incident took place in the year 2022. And there is no rectification with this regard during the entire course of trial by the investigating officer. Not they have mentioned this in the charge sheet.
Let us see the record. Records.
The very existence of seized articles comes into a question. The FIR, which dated to FIR in page number 4 of the paper. book.
Madam, one thing at a time, madam.
I'm not sure.
You're in a hurry now. You're like Rajdhani. Earlier, you were like Northeast Express. Took 5 days to reach Guwahati to Delhi. Not 5 days. 3 days and 2 nights. We used to go, we are cheap. When we had money, we used to take the faster trade. No money, take the slow trade. Yes. 7 to 2020. Was this exhibited?
Yes,
This
it
is
was.
the photocopy of.
Executive.
No, it is in the
They were exhibited.
no. Exhibit P11. 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 Inventory of these. Yes. Okay, that's all. Heard.
Yeah, please, Lordship. Lordship, my item number is item number 17 of supply list, Lordship.
Who's your client?
Mete, Lordship.
Mete.
Accused number 1, Lordship. I have appeared for the legal aid counsel. I don't have the paper books, Lordship. My matter is already admitted, but I have not filed a bail petition, Lordship.
Lordship, may I submit? Lordship, this order I have placed, madam. I'll kindly go to one.
Yes.
Para 10, ma'am.
Alright,
Para 10.
this person.
Para-
Yes.
Shall I read, ma'am?
This is for suspension of sentence. We are not suspending any sentence. We are setting aside the entire conviction. It cannot sustain. There's no question of suspension. Right. Third Miss
Albanic.
L.
Lucky one. L.
Banik.
Yes.
Any relation with S. Banik?
No.
No. L. Banik, Learned Counsel for the appellant
Yes.
in criminal appeal number 373/2024. Also heard Miss
Deep or Pujari, Lordship.
D. Borpujari.
I have a legal aid counsel, Lordship.
I know with department in criminal
36.
appeal number
36 of 25.
36 of 2025. Next paragraph. No, also heard Mr.
RR Kaushik, ma'am.
R. Kaushik, the learned additional people. The two appeals are being decided by way of this common judgment in order in view of the fact that the two appellants in the two appeals have been convicted and sentenced under section 22C. Only under 22C or some other?
21C.
21.
Under 21C
Yes.
NDPS Act by way of the same impugned judgment dated 7/8/2024, passed by the special judge Sankar Dev Nagar Panchayat in special NDPS case number 34 of 2022. Pusta. The appellants have also been sentenced to undergo rigorous imprisonment for 18 years, with a fine of rupees 1 lakh each, under section 21C NDPS, in default of payment, the appellants are to undergo SI for another 1 year. The brief facts of the case is that the is that 100 blue colored plastic packets, each containing 200 numbers of pink colored tablets, which were suspected to be Yaba tablets, were seized. From the possession of the appellant on 7/2/22. Correct? Dates are correct.
Yes, yes.
7/2/22. The subsequent to the seizure of the Yaba tablets, which turned out to be, which gave positive tests for methamphetamines as per the FSL report. No, don't say that. Just say that. Subsequent to the seizure of the Yaba tablet, well, where is the police station case number?
Fifty-seven oblique twenty.
Which police station?
Doboka PS case.
Daboka PS case number 57 of
2022.
2022. Was registered under section 21C/23C/27/29 NDPA. The examination of the seized contraband by the FSL was to the effect that the same tested positive for being methamphetamine. After charge sheet had been submitted, against the appellant under section 21C/23C/27/29 NDPS. The learned trial court framed charges under section 21C/34 IPC. The 21C NDPS. That's 21C/23C/27A. And that's all, 27. And 29, slash 29, slash 34, and NDPS, read with section 134 IPC. How is it? Yes, Master. Please read what I said. Yes, yes. The two appeals have been as challenged. No, have arisen out of the common judgment and order dated. Okay. No, I've given you the common judgment order passed by common judgment and order dated 7/8/24 passed by the special judge Shankar Dev Nagar Hojai in special in the case number 34/2020. Then next, no, then next. Appellants have been. No, not comma. 18 years with a fine of rupees. Now, one like each, comma, in default, simple imprisonment for one year. Come on, under section 21C of the NDPS Act. Okay, next, then next, but anything else? No, that's all. Okay, thank you. Okay, but I said about charge and all, charge framed and all. They're not taking it. But what was, just read, continue reading. I'm doing it so that I don't have to correct later. Numbers of pink colored tablets. Subsequent to the seizure of Boca, PS case number under section 21C. No, 23A slash 27A slash 29 was registered, was registered, full stop. Then the examination of the was to the effect found to the said contraband was found to tested positive, was found to be methamphetamine. Okay. Framed. Read with 34. Not 134, 64. How you type that? Okay. Next. After the learner trial court, recorded the evidence of 11 prosecution witnesses and 1 defense witness. Comma. The trial court came to a finding that the appellants had committed an offense punishable under section 21C of the Indian Code. The learned trial court thereafter convicted the appellants under section 21C of the Indian Code and sentenced them under 21C of the NDPS Act. The next part, the learned, the being aggrieved, the appearance have approached it by way of the present appeal. Next, the counsel for the appearance submit that the contraband that was seized having been found to be methamphetamine, comma, the learned trial court could not have framed charges and convicted the appellant under section 21C. It could have only convicted the appellants under 22C. If charges had been framed under section 22C of the NDPS. Next part, the learned counsel for the appellant for the subject. That's the, before that, before that, let's continue. According to the impugned judgment and order should be settled. Next part. The learned APP on the other hand submit that in terms of section 510 BNSS, so BNSS, no findings and no order, no finding, comma, sentence or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, a failure of justice has in fact been occasioned thereby. Full stop. He submits that even if the Court of Appeal is of the that a failure of justice has been occasioned, it may, in the case of a commission to frame a charge, order that a charge be framed and that the trial be recommended from the point immediately after the framing of the charge. Pushkar, we have heard the learned counsel for the part. Section 21 and 22 of the NDA Act states as follows. Next part. A perusal of Section 21 of the NDPS Act shows that the punishment provided under Section 21 C can only relate to heroin, while the punishment that can be provided that can be given under Section 22 you just say can the 21 no you're right can only relate to a manufactured drug such as heroin etc. While punishment that can be imposed under Section 20 can relate only to a psychotropic substance such as an amphetamine. That's all. Where does it say that methamphetamine is a psychotropic substance? In the schedule, let us see the schedule.
Schedule.
It is a schedule.
In the schedule.
There is a schedule. schedule at page 57. It is there. Correct. Next paragraph, section 2. Bracket Roman 23, small, of the NDPS Act 1985 defines psychotropic substance to mean any substance from a natural or synthetic or any natural material or any sort of preparation of such substance or material included in the list of psychotropic substances specified in the schedule. Full stop. Serial number 16 provides for shows that amphetamines is a psychotropic substance. No, it shows that amphetamine, serial number 16, amphetamines, and serial number 19, methamphetamine, is a psychotropic substance. What do I think? And serial number 19 of the schedule relating to section 2 bracket Roman 23 of the Act. What was that? Next paragraph. The above having clearly shown that amphetamine slash methamphetamine being psychotropic substances, the learned trial court could not have framed charge under section 21C in relation to the seizure of amphetamines slash methamphetamine. Consequently, in the absence of any charge being framed under section 22C, which provides for punishment in relation to psychotropic substances, the learned trial court had erroneously, could not have, the learned trial court could not have convicted and sentenced the appellant under section 21C in DPS. In view of the above, next paragraph before that. Though the learned APP was of the view, had taken us to section 510 BNS in support of his submission that the finding, sentence, or order by a court of competent jurisdiction would not be deemed to be invalid merely on the ground that no charge was framed under section 21C NDPS, and as such there was no infirmity in the conviction and sentence of the appellants under section 21C NDPS, we are of the view that section 510 BNSS would not come into play in the present case. The reason being that not only has the learned trial court failed frame charge and the section, and not only has the not only has the learned trial court frame charge under section 21C in respect of seizure of methamphetamines, which is not permissible in law. Comma. The learned trial court has also convicted the appellant under 21C of the NDPA. The submission of the learned APP would have been considered if the learned trial court had convicted the appellants under section 22C in DPS Act, even if due to some error it had forgotten to convict the appellant, forgotten to frame charge under section 22C. However, in the present case, not only the framing of charge, but the very conviction is also illegal and cannot be done in terms of, could not have been done by the learned trial under section 21. Further, now, first up, in view of the reasons stated above, it is the opinion of this court that a failure of justice has been occasioned by the learned trial court not framing a charge under section 22C and / or convicting the appellants under section 22C, in relation to a seizure made for methamphetamines. Accordingly, we find no reason to sustain. We find that the impugned judgment and order dated 7/8/2024 passed by the special judge Shankar Dev Nagar Hojai in special bracket NDPS case number 34 of 2020 is not sustainable in law. The same is accordingly set aside. Full stop. However, keeping in view the fact that keeping in view the fact that there has been a failure of a failure of justice has been occasioned due to wrong framing of due to the wrong framing of charge and also due to conviction on a wrong provision of law. The learned trial court should be allowed to frame a proper charge under section 21C of the of NDPS Act. Keeping in view the fact that the seizure of methamphetamines pertains to a commercial quantity. Accordingly, in terms of section 510 BNSS, we direct that we remand the case back to the learned trial court for framing for framing a charge under section 21C in the PSI and direct that the trial be recommenced from the point immediately after the framing of trial. Framing of the proper charge. Acha, one thing. Next, the above being said, it is surprising that the learned trial court had framed a charge under section 21C for a seizure relating to methamphetamine. However, the fault for the said error also lies with the police, who had not only registered the case but had also submitted a charge sheet. Under section 21C. The prosecutor who had also conducted the trial has also not, has apparently not considered the fact that the charge was framed under the wrong provision of law. It is surprising the mistake committed by the police, the court, and the prosecutor for an offense relating to a commercial quantity of methamphetamine is unbelievable. The coincidence in not knowing the law is too great for all the stakeholders to be to take a stand that they were ignorant of the law or did not take the pains to read the provisions of the NDPS Act. Though the councils representing the accused appellants should have also informed the court, the learned trial court, regarding the error in the charge framed by the learned trial court, comma. This court does not wish to make any observation with regard to the same.
Lordship, you were not the one to represent before the trial.
I'm not talking about you in particular, madam, not you in particular, can be, I'm talking about X, Y, Z. Okay. What have I said? Comma, though, as officers of the court, they should have also corrected the court, corrected the learned trial court with regard to the mistake that had been committed. The coincidental ignorance of all the stakeholders seems too great to what to to be ignored. As such, this court is of the view that the authorities in the police department and in the state government should inquire into the matter as to how the police and the other authorities could have committed such a huge blunder. The learned trial court who had tried the case may also be required to give an explanation with regard to how it could have completely lost sight of the provisions of law, not only at the time of framing of charge, but also at the time of the trial and at the time of passing the impugned judgment and order. Next para. It has been submitted that the appellants have been in jail for the last 3.7 months. Yes, yes. That 3 years, 7 months. 3 years, 7. 3 years, 7 months. And the Supreme Court, in the case of Dheeraj Kumar Sharma versus State of UP, Criminal Appeal 6690/2020. Should I give all these? There's a flood of cases. Why don't you apply there, madam? Trial court.
Lordship, there is very less chance of us getting a bail from that particular court. Had it been the case, the learned trial court would have given the bail at that particular point of time itself.
It is a serious offense.
Yes. Considering the lapses as well as the framing of charge. Lordship. We are bound to appear before this honorable court.
My only submission is that, my lord, at least there's this following consideration that most of the cases so far, I know, my lord, are pending trial. Now
Now
also it's pending trial only.
This is pending.
Trial only.
Now pending trial.
But the thing is that he's from Manipur.
So,
My lord, there is a flight fix, my lord.
huh?
There is a flight fix, my lord.
Meeting.
Flight fix.
There's a site list. So you think we'll give extra precaution that he has got to more strict bail bond will be more. Look, there is something going on which we do not know. The entire thing. How can methamphetamine 21C?
Here actually I observed, my lord, while forwarding report, in the forwarding report actually police wrote it down manufactured drugs, and that carried on all the way till the forwarding report, as I have seen many.
But what was the FSL say?
FSL said, my lord, psychotropic.
Then
Admittedly, yes, man, that is the mistake. Police committed the mistake. Then it carried on, man.
with the police, with the court,
Yes, man.
then it carried on with the
Till the judgment.
computer.
Till the judgment.
And of course, lawyers though they are taking advantage.
Yes.
All that.
Yes.
Though even they didn't know, I don't know.
No, Lordship.
You all knew.
Admittedly, no.
Kept quiet, but
No, Lordship, we were not there.
no, not you. I'm not talking
The
about you.
council. Maybe Lordship.
Don't take it personally.
No.
Oh. When we say you, we don't mean your previous lawyer also. We mean the accused. This is clear cut case of, I don't know. May not be so clear cut also, but there is something.
Maybe,
Everyone
maybe.
losing out. I mean, it's unheard of.
Yes.
I remember doing one case long time back when I first joined a bail application. That sees, say, green and yellow tablets, methamphetamine. What was sent to the FSL was brown and orange. What came back from there, the remainder tablet was blue and something. I mean, the things happen.
I have seen my commercial quantity police writing down it as a 22B or like intermediate one, not like this.
I know. You see, you are 510.
Yes.
Your argument was
5-1.
reasonable, provided the conviction was done correctly.
Condition also the
Conviction also was done incorrectly. Nothing was correct. What do we do?
we can apply this can apply there when this port doors are always open. Parameters of section 37 will also come.
The problem is Supreme Court gives these orders that Section 37 is not attracted when they're long incarcerated.
Those are regular. But
Same here,
I
comes
said
same here.
now it became same.
Same here.
Now it becomes.
Then
It becomes.
only thing is that can we give the same kind of this direction or observations? They think they might be able to. We have got to be slightly careful. And another thing is that if they've undergone half
That has
the
not-
period, but that is not half. You've not undergone half the period of sentence.
recently, but not Supreme Court, but Delhi High Court in Sharjil Imam Islam or Sharjil Imam case, regarding that plea following incarceration. The court has rejected because this citation with Muhammad Muslim and all these things are placed for the honorable court. That case related to the Delhi riot case. That has been rejected. Now they have although
No, but there are many cases. NDPS, so there are many cases. I can give you 10 right now.
either way there are government.
But this is a dangerous thing. Methamphetamine is very dangerous. Have you seen these persons who get high on methamphetamine? Some of them become very violent.
And these are really accessible.
Very dangerous. Very dangerous. Heroin, at least some of them, they are so yes, they're not violent. Methamphetamine, they become very violent. Very dangerous. Very, very. Some of them. So we've got to think of society also. You'll get out and then you might kill somebody. By giving tablets here and there, they will get high and they'll kill themselves, they'll kill others. Now what to do?
Lordship, so far as the concept of bail is concerned, the main provision
Okay, what have we said? has held that Section 37 of the NDPS Act is not attractive when accused has spent a long time in jail. In the case of Rabi Prakash versus State of Orissa, 2023 SCC Online SC 1109, the Supreme Court has held that prolonged incarceration must override the statutory embargo created under Section 37. Also, further, in the case of Muhammad Muslim alias Hussein versus State, SCT of Delhi, 2023 SCC Online SC 352. The Supreme Court has held that grant of bail on ground of undue delay in trial cannot be fettered by Section 37 in the PSL. In the present case, the impugned judgment and order having been set aside, and as the trial is to be has to recommence from the stage of framing of charge under Section 21 of the NDPS Act by the learned trial court. It would take some time for the trial to be complete.
Suggest something. Or it may prescribe certain limit or 6 months within that period. If that happens, my lord, it will be
It will not happen. They,
because most of the witnesses are police personnel.
but you are going to fail anyway because of that 52A. Their prosecution is not going to succeed, it appears.
But as per recent Bharat Ambale judgment, my lord, non-compliance of 52A will not visit the trial itself. My lord. Unless there are
Not, should not, but then you have not produced the thing. These articles.
my lord, that is not necessary as per that judgment. My lord.
No, but 52A,
52A, my lord.
52A inventory has to be brought. The sample that has been taken under 52A, that will have to be brought before the court, not the photograph. You see, the thing is that why we're not writing all these things what he's saying, is that you might have difficulty during trial. Right. Hmm. Come on, we are of the view that bail should be granted to the appellant accordingly. The bail is that the appellants are allowed to go on bail. On a bail bond of rupees, how much?
And just proceed previous.
No, you give us good amount. Only.
Or government share,
Huh?
local share.
On a bail bond of rupees 1.5 lakh. Well, they'll pay one. If you say two also, they'll
Yes, minimum for them.
bail bond of rupees 2 lakh. They will, you see what they'll do, probably. They'll deposit the 2 lakh with that bailer and they'll go. Will you do that?
No, Lordship, these
Yeah.
are my words on affidavit. I'll appear.
I
Let me-
I know.
Mhm.
Your words will not mean anything. Once you give the money, with 2 lakhs each, with one surety of like amount, with one local surety,
Local surety.
with one local surety of like amount, to the satisfaction of the trial court. Full stop. The. That's all.
For governments, I mean, by the theory. Otherwise, well, there is very possibility. of-
Local surety, what more?
It's in areas,
Huh?
they have local connection. Ultimately, they are going to supply in local place.
With one local government surety. With one surety, one government surety, with one local surety, who is a government servant. Okay. Uh, the bail is subject to the condition that the appearance shall attend the court regularly. And what about leaving the state?
That may be a little liberal.
Well,
Yes, staying there for a long.
okay, they attend the court regularly. Next. Uh, the appeals are accordingly allowed. Send back the TCR. That's all. And then I is also you put. You put that I also, it's one out. Huh? Yeah, same order, all in one order.
Plus,
Lordship.
No, you see, you just make it out correctly because in some I've said 21, what has happened is they were supposed to frame under 21. They 22, they
22,
framed it
they
under 21. That is why. So sometimes I have interchanged because depending upon yes, the sentence and depends upon the context in which I have made it. It'll depend. 21, 20. That are changed.
most of them.
Lordship, for appearing before the Lionel trial court, is there any, there is no specified date for them.
Okay, yes, yeah, okay, the learned, the appearance shall appear before the learned trial court on. You'll have to go and, you have to appear before the learned trial court on, give a date, what date,
Maybe after vacation.
vacation. After vacation, huh? Or before vacation, at least second of
No, because this year have to be.
we're up,
That's it.
22nd October.
Published.
May please your lordship. My lord, the IA for suspension of the sentence and we and pray for bail is before your lordship. My lord.
Oh,
The
yes, what is the case?
My lord, the conviction is under my lord, the 376 and my lord, the Prevention of Child Marriage Act and POCSO. The victim is the wife, married below the age of 18, my lord. In fact, my lord, if we,
Quiet.
my lord,
Lordship, only I'm sorry, I could not check whether notice is issued on the informant for victim.
notice was issued, but they have appeared on. In fact, my lord, objection has been filed by the state against the my lord application for suspension of sentence.
You are supposed to obtain instruction from the OC. That is what the last order says. 8/9/2020.
Yes, my lord.
Miss A. Begum, learned APP shall further obtain instruction from the OC of the concerned police station with regard to the service of notice on the respondent number 2.
And seven more. No.
Tomorrow.
What is the case, but
My lord, the FIR was lodged on the basis of some information, or there is no complaint from any court.
she is married.
My lord?
You are married to the.
Yes, my lord.
They gave birth to a baby.
Gave birth to a baby.
Then she went for check.
Ah.
May I please your lordship? Lord, I want to give the brief.
This is Mr. Counsel, we have heard everything.
My lord, I will be given just 5 minutes, my lord. I just want to. I want to clarify everything, my lord, within this 5-10 minutes.
It must be my desk with the envelope.
My lord, there is an efficacious alternate remedy available also. CGRF is there. There is entire issues with regard to his damages and everything can be brought into contention.
No,
My lord would like-
why should we go to that?
My lord, if
Why should we go to that? What is? Why should we go to it?
CGRF.
After 5 years of litigation, my lord, they're coming with this
This,
plea, my
my
lord.
duty to
We've already completed 4 years, my lord. I'm waiting for the last 4 years. Your lordship, I just want to, my lord, entire episode, they have committed illegality after illegality, my lord. Your lordship, may kindly see the notice, my lord, which they say it is a disconnection notice, is not at all a notice. Contained in the bill, it is not a notice, my lord. And that also, my lord, apart from that, your lordship, I'll just take your lordship to only few things, my lord, which will clarify everything. My lord, the notice that is there, my lord, 75, relevant 79. Your lordship, may kindly see. 79, my lord. My lord, election, this page number 79, the bill. Your lordship, may kindly see, the bill date is 13/8/2020. And the due date is 28/2020. Even if we presume that this is a bill, even in that case, my lord, your lordship, may kindly see, under section 56(1) of the Act, power supply of your premises will be disconnected at any time due to non-payment of arrears. If paid, ignore. So, my lord, how strange this is, my lord. The Act, let us go to the Act, my lord, the Electricity Act. Section 56.
Electricity Act.
Yes, my lord.
We are talking about page 77.
I have reproduced it in the, in my written argument also. 79, my lord. My lord, 56, my lord. May I read, my lord?
Yes.
My lord, disconnection of supply in default of payment. When any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, but this is very important, my lord, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights. Now it is, my lord, this act is very clear. This is very clear that only when I don't pay, my lord, then only notice is to be sent.
Correct, correct.
But here in this case, my lord, they are saying if you don't pay, this is not the law, my lord. If you don't pay, it will be disconnected. If I
Then
do,
if you don't pay, it will be disconnected.
yes, but the act says that if I don't pay,
Ah.
then notice has to be given for 15 days. That means, my lord, if I don't pay by 20, that the due date, 28/20/2020, then only they have to issue notice saying that another 15 days time is given to you to pay or to face disconnection. This is very clear, my lord. Where any person neglects to pay or any charge of electricity or any sum other than the charge for electricity due from him to a licensee or generating company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice.
Correct. Now, Mr. Council, look at this.
My lord.
Look at this page 79.
My lord.
This bill
Yes.
is dated 13/8/2020.
Yes, my lord.
You look down there, you have got arrears.
My lord.
And then you come to page 78.
My lord.
This is 1/7/2020, bill dated 1/7/2020. You have not paid this bill also.
My lord.
Then you come to page 77.
Yes, my
1st
lord.
June 2020.
Yes. But my lord, I want to say that this is not a notice at all, my lord, as per the provision of.
This is a notice. What do you mean to say? It has to be, it is set under 56. You mean to say that it should be a separate paper, separately signed or what? Where
Well,
does it say that there
well,
is a format?
my lord,
Format.
My lord, section 56, your lordship, this notice is under section 56 of the Act, of the Electricity Act.
Correct.
But their disconnection is under the regulation. My lord, their affidavit may be seen, my lord, their affidavit. How can this notice under the Electricity Act 56 be taken to be a notice under section of their notice, your lordship, which is there, my lord? Their 70. Let us see, my lord, their counter affidavit.
So the answer of it is in.
No, please, I don't want interference, please. This is the reason why I have not been appearing. For the last 4 years, my lord, I'm unable to argue the case because of my friend. So that's why I send my juniors. Please don't interfere. Please let us
I'm sorry.
be patient.
No, but then one thing you're not being fair. We have heard their juniors
My lord.
and we have basically finished hearing them. And we are going to dispose of the matter. And then now you come in also and you want to argue.
No, my lord, your lordship, last time, my lord, your lordship, last time, my lord, I could hear your lordship. I was, my lord, in Delhi, I was for treatment of my wife, my lord. I've come rush from there because of that, my lord. So, my lord, in the hospital, my lord, my audio was not working, my lord. I tried my best. I could hear submission. Then your lordship wanted me to come. So, therefore, I've come, my lord.
I didn't want you didn't want you to come. You said you wanted to come.
My lord, anyway, my lord. My lord, your lordship, you kindly see, they have specifically said, page 73, my lord. Page 73 of the paper book. Writ appeal, my lord. The writ appeal.
Yes, yes. You got it.
It is pertinent to mention herein that the temporary disconnection, it means they mean disconnection, my lord, of the petitioner premises was done as per 821 of the AERC 2017. My lord, 821. Now, they say that it was disconnected as per the regulation. And now they are referring to the notice under Section Electricity Act. How can it be, my lord? Notice is under Section 56 of the Electricity Act and their disconnection is under their regulation. Can it be possible?
So, no. Yes, sir.
My lord?
Notice is a notice.
No.
In the act, is there a provision for disconnection?
In the Act, my lord? Yes, my lord.
No.
This is the provision, my lord.
Ah.
In the Act, Electricity Act, my lord. Yes, my lord, 56.
Now you see,
Ah.
now what is the wrong in reading 56 harmoniously along with regulation 8.1? What is the wrong?
My lord,
Where is the conflict?
but their disconnection should have been under section disconnection of default of payment under Electricity Act because there is no.
So 8.2.
My lord, in the Electricity Act, my lord, there is no provision for Electricity Act. There is no provision for temporary disconnection, and this notice cannot be taken for temporary disconnection because they have only one disconnection, neither permanent nor temporary in the Electricity Act. So, but they are disconnecting for temporary, my lord. They are saying that they have disconnected temporarily.
No. In the Electricity Act, there is a provision for what kind of disconnection?
Disconnection. No, it doesn't say permanent or temporary.
So they have temporarily disconnected. What is wrong?
My lord, temporary disconnection. How can they do it?
How does it prejudice you?
How can they do it, my lord?
Why not?
This is not even the notice. And apart from that, my lord,
When there are acts, there are rules to ensure that the act is implementable. Similarly, there is an act here, there is a And this code, this regulation has been made under section 50
Clause 10.
and clause 10 subclause 2 and section 81 of the Electricity Act.
My lord,
So what is wrong?
my lord, this is the case has been decided by a Patna High Court, my lord, holding that the disconnection notice in the bill cannot be taken to be, my lord, after referring a number of judgments, your lordship, I'll give. Exactly on the same issue, my lord. It was under the old act, my lord. The same thing. The action, my lord, I read para number 3. The action of the respondents in disconnecting the two connections of the petitioners has been impugned mainly on the ground of breach of section 24(1) of the Electricity Act, which reads as follows. Where any person neglects to pay charge of energy or any sum other than charge for energy due from him to a licensee in respect of the supply of energy to him, the licensee may, after giving not less than 7 days, now it is 15 days, notice in writing of such person and without prejudice to the right to recover such charge or sum by suit, cut off the supply and for that purpose cut or disconnect any electric supply line, in other words, being the property of the licensee, though with energy may be supplied and may discontinue the supply until such charge or other sum together with any expenses incurred by him in cutting of the connecting of supply are paid, but no longer. And then, my lord, after discussing a number of judgments, my lord, this court has come to the conclusion, my lord, that para number, last page, my lord, para 30, 31. This is a division bench order, my lord. Para 30, my lord. I cannot consider the instructions appearing on the reverse side of the Annexure 2 bill as satisfying the requirement of the service of notice of disconnection or cutting of the supply as contemplated under Section 24 of the Electricity Act. I concur with the conclusion of my learned brother that the instruction contained in Annexure 3 bill does not satisfy the requirement of law as envisaged under Section 24(1) of the Indian Electricity Act 2010. It is not a valid and fair notice contemplated by the said statutory provision. In this perspective, I hold that the writ petition deserves to be allowed. Now, my lord, apart from that, your lordship, again, I may come to another point, my lord. See, your lordship,
But Annexure 3 bill may be different. What is the content we haven't seen that.
You see, in your case,
That bill may be different.
just because they have put the notice, they have put you to notice in the bill by putting the type thing, the type sentence. How does it, how is it not a notice?
my lord, it cannot be. Your lordship, my lord, I prayed before your lordship to kindly give me some time, my lord. Your lordship may kindly see the illegality after illegality committed by them. Your lordship may kindly see format 18, page 33, the one which they have said, they said they have given to me, saying that disconnection notice. Their own rules stipulates that it should be, my lord, my written argument, my lord. Page 26 of my written argument. The licensee shall intimate the consumer. This is second mistake, my lord. The licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnection. This they have never done. My lord, this never done, but they brought one document, this format 18, before the court at the time and filed their affidavit, my lord, and then said that where also they have done it after 15 months, more than 15 months, the thing which was to be done within 24 hours. They have done it for 15 hours. So this was also not fulfilled.
Better late than never.
My lord,
But because you also did not pay anyway.
my lord, I did not pay. That's why they disconnected. But they should follow. Well, they cannot.
You're only talking about the fault of the APDCL.
Yes, naturally, my lord, I had
You
to.
are forgetting.
Yes, that I did not pay.
That you see the entire
My lord,
issue.
my lord, I was at Imphal, my lord. When he put during Corona period, my lord, it was not possible. I did not have any knowledge of the bill or anything generating because, my lord, it was totally shut down all over India. It was during the
What
peak
a shutdown? What a shutdown?
peak Corona period, my lord.
Peak Corona period.
Yes, peak Corona period, my lord. And my lord, you know, see, kindly see. What about section 171 of the notice? Well, this if you presume that this notice in the bill is a notice, then it has to be done. It has to follow 171 of the Act, my lord. 171 is very clear in this regard, my lord. University may kindly see. They have also their own. 171. This is the process method of my lord.
Let us see.
Yes, my lord. 171. Which they've never followed, not at all. This bill, they left it in the table of the my building, and it was never served to anyone. These bills are never served. My lord, service of notice, orders, or this document. Every notice, order, or documents by or under this act required or authorized to be addressed to any person may be served to him by delivering the same after obtaining signed acknowledgement received thereof, my lord. Signed thereof by registered post or by means of delivery as may be prescribed. Where the appropriate authority is the addressee at the office of such office or the appropriate government may prescribe in this behalf. Where the appropriate commission is the addressee at the office of the appropriate commission. Where a company is the addressee at the registered office of the company, or in the event of the registered office of the company not being in the India. Where any other person is the addressee at the usual or last known place of the abode or business of the person. Every notice, order, or document, or by order this required or authorized to be addressed to the owner or occupier of any premises shall be deemed to be properly addressed if addressed by the description of the owner or occupier of the premises. It will be served by delivering it or to true copy thereof to some person on the premises, or if there is no person on the premises to whom the same can be reasonably diligent to deliver by fixing it on the same conspicuous part of the premises. They've never done it, my lord. Then again, let us see their own regulation in this regard, my lord. Their own regulation. What their regulation says about service of notice. They have their own regulation as well, my lord. My lord, chapter 10, 10.3, service of notice of the court. It is in the written argument, my lord. Last page. Sorry, page 28. University service of notice. My lord, I read their regulation. I was reading Electricity Act, now I'm reading their act.
Show me the regulation. What is the number?
10.3, my lord. 10.3.
This one. Yeah.
This is already, my lord. We have furnished 3 times. My lord, it is there, my lord. My lord, we are giving another copies, my lord. My lord, we have furnished this 3 times, my lord. This judgment was reserved for 1.5 years, my lord.
My lord, even I had given the
No,
last.
it was reserved with whom?
Not this court, my lord. I'm saying that during the reservation,
See, we are going to dispose it of today.
this, my lord,
We have got. We are stopping hearing this in another 10 minutes. Will you complete?
my lord,
We have given you enough time.
my lord, let us see the service of notice, my lord, 10.3. Their regulation, my lord.
Yeah.
They have not followed anything, my lord. Any order, my lord, any order, notice, document to the consumer by the distribution licensee.
You see, the thing is that the issue is you did not pay.
My lord, but if my lord, I did not. That's why all these things are happening, my lord.
Correct.
Yes, there is a provision. If somebody doesn't pay, does it mean that they can disconnect anytime
Why not?
following the procedure?
Why not?
Without following the procedure, my lord.
The procedure is followed.
Not at all.
Why
Not
not?
at all.
Why not?
My lord, they have not served the notice as per the requirements.
They have served you under 56. They have served you as per 8.2.1, which is made under.
My lord, those service should follow the procedure for service.
Is it your case that you did not receive the notice?
No, yes, my lord, I did not receive.
Huh?
I did not receive.
You did not receive?
No.
How did you pay? How
Well,
did you pay? How did you make the payment?
I came, my lord, after the corridor. I went to their office. They said today is the last day.
And how
to
is
pay.
it how are all those documents in your writ petition?
So, which document? My lord, I came here and then I got all this information from the office and from my building.
So
But not before disconnection.
according to you,
My lord.
no one needs to pay monthly bill. Electricity bill.
Everybody has to pay, my lord, but disconnection has to follow the rules, my lord. Rules has to be followed.
How long did you not pay your electricity bill?
My lord, a long time, my lord. Long time, I admit. But I mean to say that.
Since when did you not pay?
My lord, May or June 2020, my lord.
Huh?
May or June 2020.
No, June 2020.
And disconnected in August.
And when did you pay?
Disconnected August. When the last day was fixed, my lord, so I paid it.
29th March.
2022.
Yes,
So you did not pay your electricity bills for 2 years.
my lord. His lordship kindly,
And if you don't pay electricity bill for 2 years, did you ever wonder in your mind, how come I'm not paying bill? Or was it your stand that I was here?
my lord, your lordship, does it mean that, my lord, if somebody has committed a murder, can it be hanged straight away, my lord, without following the procedure?
That is why this, you see, this page 85.
No, no procedure.
Is your
My lord,
format
no procedure has been followed, my lord. No procedure has been followed.
been followed, but maybe not in the timeline that it has to be done.
My lord, this notice 56, my lord, this disconnection notice has not been served. Under section, my lord, I was reading service of notice. They are earlier 171. Now they are on the.
Mr. Counsel, let us cut to the thing. Yes. The issue is now, your electricity has been permanently disconnected. Correct?
No.
Now, they are saying, now you have paid the bill.
No.
Now you are saying that you want to reconnect. Correct?
Restoration.
Yes, reconnection. If it is disconnected, you want it to be reconnected. Correct?
Yes.
You want to use that particular word. Huh? You look, let us not go. These are all ego issues. Now, just listen. So you want a reconnection of your electricity bill. Correct? They are saying that you have to have a new connection. Now, I think the issue lies there. You don't want a new connection, you want a reconnection of your old electricity connection. Correct? So, now they are saying that even for a reconnection, some payments have to be. But because of the change circumstances, it has to be a new connection. But they have taken a plea, they made a submission, concession, they've made a concession that they will provide you a new connection at the rate of a reconnect.
At the rate of
Reconnect.
that I have already paid, my lord. Reconnection I have already paid.
No,
Bill-
only
Yes,
thing
but-
is that.
Page 47. Page 47.
Listen, Mr. Counsel. So at the end of the day, what they're saying is, you just pay the reconnection charges and they will give you a new connection. Only thing is that we have got to provide some document because it's going to be a document in terms of 4.1. Regulation 4.1. Yes. Regulation 4.1.
That is already with them, my lord.
And here it's a problem with ego. Is it so difficult to give another set of documents?
Not at all, my lord.
Yeah.
But my lord, it just amounts to, my lord, how can they be awarded for having committed the illegality and punish me, my lord?
Mr. Counsel, look, let us not go. Look, this writ, let me see. This writ appeal has been filed in 23. The writ petition was filed
22.
in 22. This case has been pending for now
4 years. Almost 4 years.
almost 4 years. You have been without electricity since 2021,
2020.
2020, 2021,
No, my lord.
2020,
August
August
20.
2020, August 20. So you have been without connection for 5 years. You are more interested in fighting with them than getting a.
No, my lord, I've become laughing, my lord, I've become laughing stock just because I have confidence in judicial system. My lord, I did everything. In spite of the fact that, my lord, it was illegal disconnection.
Mr. Counsel,
My lord,
let us cut to the chase. You see, the issue is you want electricity connection or you want to fight this case?
no, my lord, I want a restoration.
You want restoring.
My lord.
So they are willing to restore your thing. And prima facie, we don't find any mistake on their part, except for the fact that they did not follow the timeline. That's all. So, but since they have given an undertaking, given a concession that they will reconnect the electricity on the basis of the disconnection charges that will have to be
That I have paid, my lord.
reconnection charges
That I have paid.
and
It is there on record, my lord. That I have paid.
whether you are paid or not, Mr. Council is not the issue. That you settle it between you two.
It's
So,
been paid, madam.
if you
been paid.
It has, the reconnection has been paid.
Then-
We are ready to provide him a new connection. Provided he gives us the new set of documents and we will give
you
him
give in the new set of documents that is required under regulation 4.2, 4.1,
full one, madam.
4.1. That's all.
But my lord, I'm still of the view that, my lord, I am not required to do anything because, my lord, the Bihar case
You're not
also.
required to. Patna High Court is, we're not bound by the Patna High Court. We don't subscribe to that view.
My lord, their direction was issued to
Mr.
restore.
Council, you go to Patna High Court with your case. We cannot give that.
And my lord,
We
also
we don't subscribe.
my lord, I'm also entitled to the compensation damages, my lord.
You go to the trial court, we do not know what compensation you are entitled to.
And damages,
Compensation
my
for
lord.
what?
Damages for illegal disconnection.
Have you quantified the damages? Have you quantified the damages you are entitled to?
At the relevant time, I was getting 30,000 per month, my lord. Now it is almost
No, Mr.
60,000.
Counsel, look, we are
No.
talking about the rental agreement that you had. That rental agreement was valid for how many years?
11 months.
11 months.
It
When did
continued.
it end?
It continued, my lord. It was extended.
And his own admission is there in his legal notice that after the establishment High Court of Manipur, the use of said premises was stopped and same was rented out. However, due to it has remained vacant, which is vacant
Correct.
till date.
That 2006
for
or something. When did that pay?
Page
It was
page 48.
because of the disconnection, my lord.
No.
My lord, my lord,
After the last 2-3.
my lord, is it the fact that, my lord, your lordship is of the opinion that the disconnection is legal, my lord?
Mr. Counsel, I think we decide the matter.
My lord.
We have heard you and we'll pass the order. You do whatever you.
My lord, in fact, 56.2, the one he has from the court, it shows, it gives us a right to give a email or through phone number. So in this case,
Anyway, we have heard, no point. We have heard his juniors at length earlier. Now we are giving him a choice. And let us see. It says here, High Court, however, during the last 2-3 years, it remained vacant, which is vacant, that is on 22. Anyway, before
4
that,
years, 4 years, my lord.
my lord, just his written argument, just have para 20, page 28 once. My lord, page 28, just his written argument, page 28.
Page 20. Can I have the copy? 28, yes.
My lord, this is service of notice. Next page, page 29.
It is synopsis.
Yeah, or the written argument. Written argument. His written argument.
This one.
Page
29.
29, yes.
A notice also may be delivered by any of the following means: fax, email or SMS or any other electronic mode.
But where have you done it?
If I have not done, how did you receive it?
Where is that?
20, page 29. See, my lord.
So does it mean that I have, let us presume that I have knowledge of all the bills, but I did not pay. Does it mean that you can, no, you need not follow the rules, your own rules, that service of notice of disconnection or information of within 24 hours that it has been disconnected? Can you do that? Or Form 20, Form 18, just because I have the knowledge?
Here's page 49. However, even after disconnection, that the power connection of the aforesaid unit was disconnected sometimes 2 years back. His legal notice by the office of SDO CG. However, even after disconnection of the electricity connection, the office continued to generate electricity bill. His admitted position, his own legal notice. Not aware of it.
You know, it doesn't mean that if somebody is the consumer has got the knowledge of the bills, but and he keeps on not paying it, they need not follow the rules.
No.
It doesn't mean.
Look, if you want to file damages, you have got to quantify the amount and the loss that you suffer. For that, you need evidence, you go to the trial. There is no quantification of the loss or the compensation that you claim in the report. I don't think you have made a mention of any amount. We cannot just say that you should be entitled to this for that.
Well, they are contention that just because I have the knowledge, presuming knowledge, they need not follow the rules, fellow. It is not like that. They have not followed any of the rules, neither their rule or the Electricity Act.
Hers,
Happening in person, madam.
it's the eighth hour, Leonard,
BP Sahu.
it's the BP hour. And no, this is the petition. And the petition, let it pass for the. Hearing concluded, judgment reserved.
Much obliged. Malad, only one sentence, Malad. Only one sentence. I left it. Malad, the learned single judge directed him to produce the order of disconnection, which they never produced. I have annexed the order here in Malad. The courts of the learned single judge's order, saying that directing him to produce the disconnection, the file containing the disconnection, which he never produced. Malad, page 25, Malad. Page 25. Mr. Sharma, learned single counsel prays for adjournment to produce the reports of the case in original, which may contain the decision and the reason thereof as to why the electricity connection has been petitioner was disconnected. It was never produced, neither before the learned single judge nor now. So there is, without any order, they have just whimsically, arbitrarily they've disconnected.
That is water that has already gone under the bridge, gone, disappeared. That we are aggrieved by the single bench. That's why you have come here. We do not know what happened to that. That's not a decision. Item 30.
13,
13.
Nepali, she appears for a victim. These are legs. Let it come out of the. Your lordship, the place is like, these are.
This 302.
evidence of- No, also.
Also, fix it. So,
Lordship, my senior.
and even if you all don't come tomorrow, Mr. Council, we're disposing it off. You all have to come and sure.
Lordship, my senior is on legs.
Will I tell? I'm like, who is the senior?
Mr. H.
HRH. Why don't you argue, madam?
Lordship.
Why don't you argue the matter?
No,
You're not prepared.
no, no.
Okay, right. On the prayer for adjournment made on behalf of Mr. HRH Chaudhary, let us transfer for the appellant, who is on legs in another court. This is the matter. After we